Welcome to the special session of the Iowa Supreme Court held at Valley High School Performing Arts Center. It's a privilege for us to hold court at Valley High School this evening, and thank you so much for taking a part of your evening and spending it with us. We have one case that will be heard this evening. That case is State of Iowa versus Donald Benjamin Earl Reed, and we'll now hear the arguments in the case. Ms. Reynolds, you may proceed.
Thank you, Your Honor. May it please the Court. I'm here tonight representing Mr. Reed. He was convicted in a jury trial in Black Hawk County. Several, mainly drug-related charges. He was sentenced to a sentence of up to 100 years. As our previous speaker explained, he was the first appeal, so to speak, that went to the Court of Appeals was affirmed. His saying everything was done correctly, and I appreciate this court has granted further review to give Mr. Reed another opportunity to present his case. Issues raised on appeal, as was discussed, a sufficiency of the evidence regarding constructive possession, not actual possession, ineffective assistance of counsel in 3 respects, and the cruel and unusual punishment regarding the Brugger case. That's my plan to focus on the sentencing and sufficiency. Tonight, I think the 2 very interesting issues, and we'll see how it goes. The facts of the case, and this all started April 11th, 2012. The search warrant was executed in a house in Waterloo on Randolph Street. Defendant at that time was 27 years old. The police had been watching for a few weeks. They saw the defendant and Alicia Buchanan going in and out of the house. There were a couple small children there. They saw short-term visitors, which the police tell us is a sign of drug dealing.
Well, the children included a child of Mr. Reed, right?
Correct. One of the children was Mr. Reed.
And Mr. Reed was seen at the premises between 9 and midnight, and then later the next day, the day the search warrant was executed, right?
Yes, he was. It's interesting to me because the surveillance, they talk about a few hours. There's a few quotes in the appendix in the transcripts where the police officers, several testified, talked about we did surveillance for a few hours at a time.
Well, don't you think a reasonable jury could conclude that Mr. Reed lived there?
Well, you know, I like the quote from one of the cases. It says there's a critical line between suspicion and proof beyond a reasonable doubt. And I think that's certainly true in this case. I believe, as you say, Your Honor, the record shows that the police watched the house from 9 till midnight, and Mr. Reed's car was there. He was there. They came back about 9:30, I think, the next morning, and, you know, the car was there again, or the car was still there. I don't believe they ever did overnight surveillance.
Let me ask you just reverse. What evidence is there that he did not live there? Or is
Well,
there any evidence?
I think there is evidence that he didn't live there. The house apparently was rented in the name of Mr. Chad Wolf. The utilities were in the name of Mr. Chad Wolf. There was some evidence of a prior address. The state talks about there's a bill and a receipt for renting some property from a rent-a-center, and I think that lists his father as living at Real Street, R-I-E-H-L. So Mr. Donald Reed had a father that lived in Waterloo also with basically the same name.
But when his car's there at midnight and it's still there at 7:30 the next morning when the police return, couldn't a reasonable jury conclude that he spent the night there?
I don't know that they could beyond a reasonable doubt, Your Honor. It's really not a critical, it's certainly relevant to the critical issues, but it's not the issue. Whether he lived there or not, that's not a crime.
Well, there's a large pair of male pants that the drugs are found under
Yes.
in Ms. Buchanan's bedroom, and those weren't her pants, were they?
Right. Well, and there was, of course, some evidence that Mr. Wolf was there that morning of the arrest.
For 15 minutes?
Right. There was the ID of a Raymond Brumfield in the cocaine. And the thing that's lacking to me here is car keys, wallet, personal products, mail, very little of that. I mean,
other than the clothes that one pair of pants, was there any other clothes of his found at the premises?
The police officer's testimony that did the search is men's and women's clothing. No shoes. I don't know. I mean, I don't know what was there, but it's not very complete and not very detailed. They say, well, the bedroom of two adults, and they, like I say, they talk about, they thought, it was conclusory, that's the word, that the police testimony was conclusory about a man and a woman living there, because the only detail we had was the pair of pants.
Well, Mr. King, or Mr. Wolf, excuse me, the lessor of the property, was also seen entering the house on the day of the execution of the warrant, was he not?
Yes. And somebody just said he was there for 15 minutes.
Mm-hmm.
So.
Well, what do we know about the pants? Do we know anything about the size of the pants?
Well, sure, there was testimony that they appeared to be a men's pair of pants, and there's testimony about the size of Ms. Buchanan and Mr. Reed, and, you know, they were more likely his than hers. I don't think there's any argument about that. But
well, what about the person,
Chad Wolf.
Yeah. What's the likelihood that they were his rather than Mr. Reed?
Yeah,
Or
we don't, I
is
guess
there
that
anything?
we don't know that. And there
What
was,
evidence is there in the record to suggest one way or the other?
Right. And there was also, speaking of Mr. Wolf, there was evidence that he was the tenant in a previous house that Buchanan and Reed lived in. So obviously they have a relationship.
So the cocaine is found under the pants, in the pot. How close, in terms of how many feet away were the two firearms?
The police testified 3 or 4 feet away. I remember the pictures pretty well. I mean, they were way up high and on this big kind of shelves.
And Mr. Reed's cell phone had a picture of that built-in cabinet or wall?
I think that's correct, yeah.
Okay,
I'm not
and
sure.
did the police testify that a barrel of the gun was visible?
The barrel of one of the 2 handguns was visible behind an Xbox.
Okay, could a jury infer that Mr. Reed knew those firearms were there?
Well, and then we have one of my favorite phrases from the Kern case, which is quoted in Tremaine Thomas, about, oh, here it is. Oh, agreeable bystander. It's certainly, I mean, we're talking about proof beyond a reasonable doubt versus Mr. Reed being an agreeable bystander.
Now, in Kern, the boyfriend who also lived in that house with the marijuana grow operation testified those were his drugs, and that helped our court conclude that there was insufficient evidence as to the woman who was living there. But here we don't have anyone saying, hey, those are my guns.
Right. We do not have somebody taking the fall, so to speak.
But you have somebody else's fingerprints on the weapon?
Right, and not hers, not his, not Buchanan's, not Reed's. But what we do have is Ms. Buchanan. So I think Mr. Reed left the house. They watched him leave. He was gone maybe, I'm not sure, 10, 15, 20 minutes, something like that, and they stopped him. And then they broke into the house because she wouldn't come to the door, and she ran. I mean, she reeked of pot, of smoked pot smell, of smoked marijuana smell, and he did not. They found him in his car, completely clean, so to speak. No marijuana on him, no drugs on him. So I mean, that's not her taking the fall, but certainly her looking more guilty than him in terms of drug use that day.
Are the drugs and the guns linked? I mean, so we have drugs in the bedroom, and then we have guns, as you suggested, a few feet away. But could a reasonable jury conclude, well, whoever was associated with the drugs was also associated with the guns? After all, if one has a substantial amount of drugs, there's an issue of safety, and guns go part and parcel with it. Could a reasonable jury make that inference?
Well, I think, again, we're back to the question of beyond a reasonable doubt. And I know that I sort of raised the constructive possession issue, everything together, the guns, the drugs, and everything. But, of course, they had to be linked in the legal elements test as far as somebody being within reach of the guns while,
All right, so you're
dealing
saying
with
it's possible we could conclude that the guns are not associated with the drugs, or in other words, we could conclude there's sufficient evidence on the drugs but not in the guns. They
Yes,
don't
Your
necessarily,
Yes,
they're
Your
not
Honor.
necessarily linked.
I think I didn't make that argument as well as I could have, but I appreciate, I believe it's in there.
So if hypothetically we were to conclude that the evidence was insufficient on the guns, but affirm the conviction on the drugs, and he's going to have a resentencing, would we then need to reach your Brugger claim on the constitutionality of his existing sentence if there's going to be a resentencing?
Well, I think, the court needs to make decisions on all the issues, I guess, but like you say, not necessarily. If you decide one issue, you can stand aside on the others. But I think that the best argument for a Brugger resentencing is Lyle. I mean, I think we can't look at Brugger 09, Lyle, or Miller in 2012, and...
But he's 27 years old, and Lyle made clear that it only applied to people under 18, didn't we?
Right, but in Brugger, the prior offense was that he was a juvenile.
Does it matter that in that case he was 12, it was a preteen offense, and he could not have been charged as an adult?
I mean, I think it's clearing an argument, Your Honor, but I think, as Lyle says, we have to draw the line somewhere. And I think it's not a very workable standard if we're not saying under 18 in Brugger.
But what would a hearing have done for Reed in this case if the court would have given that to him when he was 17 years old at sentencing? What would it do to this case?
Well, I think the remand that I'm asking for Mr. Reed would be a Miller factors type hearing. I mean, the sentencing transcript and his PSI show many just disturbing factors. He's basically saying he was taught to deal drugs by his parents. Both of them have been to prison. He lived on his own since he was 14.
But if the purpose of the hearing in Lyle is to determine whether or not it's appropriate to sentence a juvenile offender to a mandatory minimum, how would that affect the outcome of this case? When he's 28 years old now and he's being sentenced for a different crime.
Right. I think, though, I think Brugger and Lyle have to be looked at together. Particularly, I think, to draw the line at under 18, I think Brugger needs to be sort of finessed to consider Lyle.
Well, Brugger was an adult, of course.
Right.
And you had a juvenile strike, if you will, albeit, I think, 12. In this case, your client was 17, I believe, when the precursor crime was committed. The state suggests that therein is a substantial difference. It's one thing to be 12 and commit a crime, and it's another thing to be 17. What's your response to that?
Well, I think, I'm not sure I can add to what I've already said, that I think, 12, 13, 14. Well, frankly, I think the difference between a 12-year-old and a 17-year-old, some kids, not that much, compared to the difference between a 17-year-old and a 26-year-old.
But for you to succeed on this case, aren't you just asking us that we can never count a juvenile strike? Even though this isn't really a juvenile strike. You can never count a crime for enhancement if they were a juvenile, whether they were charged as an adult or a child. I mean, because that's what you're asking us to do, I think.
But I think not. I think what Brugger says is that he could get the same sentence, but the youth of the prior offense has to be considered. That's my understanding.
But he was charged as an adult on the prior offense. He wasn't charged as a minor, so some court, and I think it was Wisconsin, made a determination that he wasn't so immature that he should be charged by a minor. He should be charged as an adult. So are we going to second guess what the Wisconsin court did?
Well,
I mean, that's what you're asking us to do, and I don't know how we can do that.
Well, I know in this state, it's an automatic. If it's a particular crime, it's an automatic filing in.
I thought I read in the record he was waived adult court in Wisconsin.
We don't have too many details, I don't think, about what happened in Wisconsin.
But we know it was an adult conviction as opposed to a juvenile adjudication in Brugger.
Just like in Brugger. No, Brugger was an adult conviction. Brugger was...
Not the first one.
The first strike. And just as in this case, the first strike is a juvenile. The difference is 12 versus 17. But in seats, we said adolescents, even at 16 or 17, are immature in their psychosocial and emotional development and this likely affects their decisions about involvement. In light of the science, the fact that the defendant is nearing the age of 18 does not undermine the teachings of Miller and Nunn.
Yeah.
So if that were true, you might have a case under Brugger.
I mean, it's fascinating to me. In the last 10 years, the law has changed. The U.S. Supreme Court and in this court with juvenile, and I don't think we can look at Brugger without looking at
Let me
Miller.
ask a clarification question. I realize the sentence is an indeterminate sentence up to 100 years. What is realistically, or let me put it this way, what is the earliest that Mr. Reed could actually be released from prison? How many years would he have to serve?
Of course, it's up to the prison and the Board of Parole and all that, but because it's not a limitation on parole, it's a minimum, but I believe the 33 and the third years could be cut in half, and yet, looking at the law enforcement report, it says something more like 22 years that he would have to serve.
So somewhere in the
Yeah.
17 to 18 to 22.
That's my best guess, yeah.
Counsel, I want to just for a moment go back to the constructive possession analysis. And if I understood one of your earlier answers, I think you suggested that the resolution of the constructive possession of the guns might be resolved differently than the constructive possession of the drugs. And I question that. I want to make sure I understand your reasoning that you are offering in support of that determination. Why would we conclude that that the defendant maybe constructively possessed the drugs but not the guns? What is your
I mean, it may
rationale?
be something as simple as it was on a lower shelf and more accessible. But I have trouble, dividing them also, but I don't think it's wise for me on his behalf to make kind of an all or nothing argument. I think if the two can be separated, that would be good. I see,
Right.
I guess my time's not up. Oh, good. I wanted to say something else just for a minute about Webb. The difference between Webb and the record we have here. I don't think there was any issue at all in the Webb case that he lived there. So we want to compare Webb to this case. There are pluses and minuses, but I think that's a real crucial one, that there was a lot more evidence that Mr. Webb actually lived in the apartment than in this case. I think it's really kind of scant evidence that he lived there.
Thank you, counsel.
Thank you. Oh, I
Ms.
was-
Hines.
May it please the court, counsel. My name is Linda Hines. I represent the state in this appeal. Turning first to the constructive possession issue, the court has said that when somebody is not caught with a drug or contraband red-handed, it's up to the law to balance between getting a conviction and protecting a person, an innocent bystander, who's just in the wrong place in the wrong time. And in this case, the Court of Appeals correctly found that Mr. Reed was not an innocent bystander in the wrong place at the wrong time, but rather that he did jointly, constructively possess.
But, you don't get convicted. You don't even have to be, if you're just a bystander, you're okay. You don't have to necessarily be innocent. In Kern, there was certainly evidence from which one could conclude that the defendant knew all about the pot operation, but there was no evidence pointing out that it was her operation as opposed to his. And on that basis, we reverse the conviction. Isn't that right?
I'm not sure I heard you correctly. The acoustics.
I'm sorry. In Kern, and that follows from some other cases, where there's a situation where we have two people in a house or two people in a room or two people in a car, and there's evidence that one of the people knew about the contraband, but there's no evidence that that person possessed the contraband as opposed to the other person who occupied the vehicle or the room or the car. Generally, in that scenario, we say the bystander, you can't convict them of constructive possession. Isn't that right?
Yes, in that case, I think that isn't the innocent bystander scenario. Where,
Well, I'm just saying, the person doesn't have to be innocent. They can know about the contraband.
Okay.
I mean, the guns were in plain view, right? But where's the evidence that the guns were connected to Reed as opposed to Buchanan?
Well, that's the state's this evidence was developed on both Buchanan and Reed. They shared this residence as well as two previous residences, and she was charged with possession of the firearms as well. It was a joint constructive possession case, and there was enough for each of these people there was enough evidence to show each of these people had the authority and control of the drugs and the guns.
What's the evidence linking Reed to the guns? Reed specifically to the guns?
Well, this is a bedroom shared by a male and a female, and obviously Mr. Reed and Mrs. Buchanan.
But how do we know it wasn't Chad? Chad wasn't sharing the bed.
Well, I think the fact that it was in plain view is a very key piece of evidence, where he had just to walk in the bedroom and could see the guns. It's behind the Xbox, and moreover, it's really close to the cocaine. And there was testimony from the officers that drug dealers tend to keep their cocaine near their firearms just as a protection.
Well, but didn't Officer Savage say that the defendant resided at a Real Street address? I mean, there was evidence in the record that he didn't live there?
Well, I think that there was evidence from the jury. There was more evidence, and it was more persuasive to the jury that he did live there. And I can go through some of those factors.
I'd like to hear them, yeah. Please.
Pardon?
Yeah, I'd like to hear the factors that...
Okay. The police conducted surveillance beyond just the night before the execution of the search warrant. The police had started surveilling this house March 24th, 2012, and they were actually looking for a different person who had an outstanding warrant. But they noticed that Mr. Reed came to that house often, entered the house without knocking.
Isn't that consistent with having a daughter in the house?
I'm sorry.
I'm sorry, I need to speak up closer to the microphone. Isn't that consistent with having a daughter in the house? He's a visitor, surely, but does that connect him?
Well, that's an argument that could be made to show that, I mean, he could be, yes, but we have more. We have the fact that he did seem to be a part of the household by opening the door and not knocking, by taking the trash to the curb, and by staying longer periods of time. And then before the search was executed too, there was a trash grab in which the police found, among other things, that there was a rent-a-center bill with both Alicia Buchanan's name and Donald Reed's name, listing that address as theirs.
Counsel, that sounds to me like it is tending to, at least to a certain extent, establish some sort of dominion and control over the residents. But as Justice Mansfield has pointed out, what we're looking for here is dominion and control over drugs and guns, where you have more than one person in the house and with access to the house. So how do those facts that you're just referring to get to dominion and control over the drugs?
Well, there's some other facts I can add to that to help you find that. I agree that right now, even if he's a resident of the house, he does not have exclusive control over the items in the bedroom, in the male-female bedroom. There's a child's bedroom too. But then he made some incriminating statements when he was arrested to the officer, and he offered to help them with the case. These incriminating statements weren't necessarily confession, but they certainly show that he has some knowledge of the drug culture in Waterloo.
But that again goes to one of the elements of constructive possession, knowledge of the contraband and knowledge of the fact that it might be contraband. But I'm still looking for the dominion and control over these particular pieces of contraband.
Okay.
So if you could address that, please.
I will go on with the evidence that showed that when he was stopped driving away from the residence, he had over $500 of cash in his possession.
But no drugs.
No drugs, but he also had nobody knew of any job or employment he had or any business that was run out of his house. So the more he begins to look, I think, like somebody who's dealing drugs, the more he has a connection to the drugs that are found in a bedroom that he occupies. And particularly in a bedroom that he occupies and in jeans that he owns.
With respect to any evidence in the record as to Mr. Reed's employment, did that testimony come from the law enforcement officers?
Yes.
Yes,
Your Honor.
So you're asking us to conclude that if the law enforcement officers didn't know whether he had a job, that's good enough?
Well, I think that when you read the trial testimony from that officer, it's clear that he's familiar with Mr. Reed. And I think that by virtue of that familiarity, he can make an intelligent guess about whether he's employed
Can I
or
ask
not.
a more basic question, which bothers me about this case? The purpose of the enhancement for having the gun is that they don't want people on the street dealing drugs with a gun in their pocket, because that's a dangerous situation. But how can you have immediate possession of a gun with intent to deliver when you don't even have the drugs or the gun in your possession? I mean, how do you even get to the elements of that crime? Because what if the gun was laying on the dresser across the way? Or what if the gun was in a drawer somewhere not next to it? I mean, how can you prove that when he was possessing with intent to deliver, he was in immediate possession of the gun? Now, we have constructive possession of the drugs, but I don't know about constructive possession of a firearm. I mean, where's that law from?
Well, I think it falls with how closely the firearms were in comparison to the drugs, and the officer's testimony that drug dealers often have guns around their drugs because they need the guns.
But somebody who has a gun in the house and you get them on constructive possession of a drug, you can make that argument all the time. And the purpose of that, as I understand it, was to prevent people from carrying guns and selling drugs, because when the deal goes bad, someone could get hurt. I mean, it doesn't make any sense how he was in immediate possession of the guns when he possessed the drugs to deliver it when you have constructive possession. And explain that one to me.
Well, it was in possession during any part of the acts of the crime of possession with intent to deliver. And that act starts with the first act, probably acquiring the drugs, and it continues until an arrest or something else. So he had the guns in his possession during the course of that.
What if the guns were across the room? Let's say you could prove that they were his guns, his fingerprints were on them. He had his name engraved on them. You know, you could prove they're his guns, but they were across the room from the drugs. Would you still have the same charge?
If the guns were across the room and had those,
The drugs were here and the guns were there.
Yeah, I think he would if it's his bedroom and he can see those.
What if the guns were in the living room?
That's a tougher call. But they were in the place where he spent his nights and kept his clothes and kept his drugs, and they weren't very far away. I think that's sufficient to show dominion and control.
What's the state's position that if, hypothetically, we've held there is insufficient evidence to connect him to the guns, but affirm the drug convictions, should we reach the constitutional challenge to his sentence based on the prior felony conviction at age 17, because that issue is going to come up? They'll make the same argument on remand, or should we wait until there's a resentencing and see what the new sentence is?
I think it would be the better mode to find that even if the drug or if the gun conviction is thrown out, this was not a grossly disproportionate sentence. I want to kind of layer how the sentencing went, because
Right.
It's important to know that he got 25 years, a Class B felony, because of the amount of the drugs he had. And then he had a possession of a firearm, and that doubled that 25 years. And then it was because it's his prior conviction that allowed it to be doubled, and it could have been tripled. That's what the PSI preparer
Or left at 50?
or left at 50. And then some of his other sentences were, because of the court's sentencing plan, some of the sentences in the other cases which he was convicted were allowed to run concurrently. If it were just a subsequent, he could have gotten up to 75 years with the tripling of the...
Did the trial court have discretion to waive the 1/3 mandatory minimum?
The way I read it, the statute, they don't, but it does, there is a statute that specifically says that even with when the minimums are imposed, mandatory minimums are imposed, a person can earn good credit time. And so his time would have been reduced by a 1 2/10 day every day he was in prison.
So what's the earliest he might have been, he could be eligible for parole under the existing sentence?
I haven't done the exact math. I think it's between 15 and 20 years, though.
And the latest is 100 years.
Pardon me?
And the range is 100 years. He might be in prison
Right.
for 100 years.
That's correct.
Let me ask this series of questions. In Robinson versus the United States, Supreme Court at least said you cannot be sentenced to criminal sanction for being an addict. Well, one, I suppose, could argue that Reed is an addict. He's a crack addict. As a youngster, he's drug involved, as the PCI says. He's got a drug habit. It's expensive, and therefore he ends up selling drugs. And he ends up, because he's an addict, he possesses drugs, he sells drugs. And we've ended up with a 100-year sentence for a drug addict. How would you respond to that line of questions?
I'm not sure. I'm really having problems here. Are you saying that the previous conviction was one committed while he was still a juvenile?
Yeah, I guess this line of questioning is focusing on addiction. Mm-hmm. Now, Robinson stands for the proposition that you can't criminalize someone because they're an addict, and that seems fair enough. Now, this guy isn't just an addict, obviously, because he's got 2 criminal adjudications involving, one involving distribution of drugs. The earlier one, it was accomplice liability, I think, but in any event, the most recent conviction involves selling drugs. But the argument could be made that an addict, a crack addict, is addicted to the drug. It's expensive, and the only way you can support a drug habit is by buying some drugs for yourself and selling them on the market. And does this fit Mr. Reed? And if so, is it fair to give somebody 100 years for being an addict in the logical sequence that arises from the addiction?
I don't think this would fit Mr. Reed at all, but because in between the time he was 17 and committed that first offense and the time he's committed the offense at issue, he's continued to commit many crimes, not just theft crimes and battery.
Trying to get money for his drug habit.
Well, it's not clear. There's battery and assault and interference with official acts. It's crimes that don't necessarily speak to trying to get money.
What evidence in the record is there that he was in fact a cocaine addict? Can you point me to anything in the record that says he was a cocaine addict?
No, in fact, I think that the evidence shows that he sold cocaine and probably smoked marijuana. I think that inference is clear there from the evidence.
Individualized hearing, we might be able to sort all that out, I suppose.
Pardon me?
Individualized sentencing hearing, we might be able to sort all that out.
Well, I will say this, though. When we're looking at grossly disproportionate sentences, the court gives a great deference to the legislature, and it's very rare for them to find that the penalty is grossly disproportionate. And one of the things you also consider is the criminal history, which we have here. And the unique factors that were present in Brugger are really not here, other than the fact that it is a dramatic sentencing enhancement.
Of course, but Brugger didn't establish a ceiling. Brugger, first of all, in Brugger, no state constitutional standard was raised other than the federal standard. And in Brugger, we did cite 3 factors, but they weren't the only factors. I mean, what basically Brugger says is that there's a point at which a sentence is so out of whack with what justice requires that the court may allow an individual sentencing hearing. What's so harmful with an individual sentencing hearing in this case? Let's find out what's really going on and find out if this person needs 100 years in jail or whether the person needs drug treatment.
Well, I question whether there is even a modicum of information that would caused me or anybody else to believe that there was some mitigating circumstances in his previous conviction at 13. He committed a manufacture with intent to deliver, and he was sentenced and spent time in prison.
I think
he told the court about this. He admitted he did it. His sister wrote a letter to the court explaining his childhood circumstances. So I'm not sure that there would be anything else which he could present that wasn't presented here and wasn't considered by this court.
Well, if there's nothing else he could present, what's the problem with the remand? I'm not sure I see it. I mean, we could have it on PCR, I suppose. That's the other option.
That's true, and I guess what my position would be is that given the fact that this is a drug dealer, a long-term criminal who has a gun in his house, 2 guns in his house with 2 children, was given a 100-year sentence that he probably won't serve nearly half of, not even. That this is not a grossly disproportionate sentence to start to require that kind of individual sentencing. See, my time is up. Respectfully request this court affirm Mr. Reed's conviction and sentence.
Thank you, counsel. Ms. Reynolds, rebuttal argument?
May it please the court.
I guess I just want to follow up. So it's your position that this 100-year sentence with the mandatory minimum of a third, understanding that there's somewhere between 17 and 22 years that he's going to be out of prison, is that something that you're obviously saying that is off the charts using the language in Brugger? Is that what you're saying, that
Yes,
this
Your
is
Honor.
completely off the charts, even though it's an enhancement for second offense, delivery of drugs, and possession of guns? And you think that's off the chart?
Yes, and I think we also need to look at the victim in this case as opposed to Brugger and what's that other case?
Well,
Oliver.
victim in this case, my heavens, I mean, crack cocaine is highly addictive, and he is selling it, apparently. I mean, assuming guilt now, assuming getting over the public safety argument would be, well, I mean, this is more than just possession. The addict who has this unfortunate habit but is not selling it to people on the street, that's one thing, but if we go along with the conviction, there's a public safety dimension to it, surely. The argument could be made we should lock up people for 100 years that are selling highly addictive crack cocaine on the street.
Well, I'm certainly not saying it's a victimless crime, and yet I think, I believe that DSM, the physician's booklet, or whatever that Bible is, now they say it's a mental illness, that addiction is a mental illness.
The
What
PSI doesn't
evidence
really...
is there that he is addicted to cocaine?
There's not a lot of...
Was there any in this
well,
trial
I
record?
think we have his admissions that he, used a lot of other drugs, ecstasy and pot and other things.
But not cocaine?
Well, it's hard to say, if he was trying to protect himself by not admitting that, an association with the drug they found. I don't know, Your Honor, but you're right, there's not a whole lot in there. Well, another thing, I want to mention a few things here. Tremaine Thomas, I think this is kind of speaking of the big picture, and the dissent, I think it is, in Tremaine Thomas's case talks about how many, basically says, we have too many people locked up for drug offenses. We have too many African Americans locked up for drug offenses. I mean, that's relevant to this case and would be something, I think, that would be looked at if he got the Brugger type of hearing, he got some kind of resentencing hearing.
Is the Brugger hearing you're contemplating, would that involve the specifics of the conviction at age 17 in Wisconsin? Or can you tell us what will happen at that hearing?
Right. I mean, I guess it would be kind of a new thing, but I think we know so little about that. And it was possession with intent to deliver less than 5 grams of cocaine at age 17. So it's a very small amount, and I think we don't know much about it. We don't know the statute, the particular statute that was violated. That's not part of the record. So
Miller, I mean, there are hundreds of decisions that are following up on Miller v. Alabama around the country. Have any of them said you get an individual, when you're now an adult offender, that you get a Miller hearing because of an enhancement from a conviction that happened when you were 17 or under?
Not that I found, Your Honor, but I think it's, there's some language in the cases about I was proud history and our cruel and unusual punishment clause and how that's interpreted. We are affording our citizens more protection in a lot of areas.
And so far, all these cases have involved a statutory mandatory sentence. Here, didn't Judge Greer have a lot of discretion?
Right. Could have been nothing done. It could have been left at 50. It could have been doubled or tripled. It was only doubled.
Did he have discretion to waive the one-third mandatory minimum?
In the record is an indication that it is. And last time I looked at the statute, I remember thinking it's something about how it isn't meth, that it can be waived. But I think that's only if it's your first offense, and maybe it is. Since it is the first Iowa offense, so maybe it was waivable. That's what was discussed at the hearing. Just a couple quick things, I guess. The Rent-A-Center paperwork was not signed by Mr. Reed, only by Ms. Buchanan. I think that's, and his incriminating statements, slightly incriminating from the jail, I think was indicative of him being the agreeable bystander. That she was the drug dealer, or Mr. Wolf was the drug dealer, but, the fact that he knew drug dealers wasn't necessarily an admission. And, the only testimony about the job was that there was no business being run out of the home. They never watched the home at night. Maybe the guy worked at night. We don't know that. I think my time is up. Yes,
Thank you,
I'm
Counsel.
over. Thank you.
That concludes the case. Before adjourning court, however, let me just make a few brief comments. The first is to thank you again for spending your evening with us. It's very important for the role of courts to be understood, and we are pleased to have had an opportunity to share some of that understanding with you tonight. Thank you. Courts function as a branch of government, and we participate in governing and through the process of governing by the decisions we make in the cases that come into our court and brought to us on appeal across the state by Iowans, just like the case that you have heard this evening. The decision that we make in this case and the decision that we make in all of our cases then become part of our history, which has been oftentimes a very proud history in Iowa. And that history helps define who we are and helps give a greater definition to our meaning of justice. So we will now carefully consider this case and how it enhances that meaning. And the decision that we make will probably come sometime between 2 months and 3 months from now. And if you're interested in following along, we file our opinions each Friday, and a list of those filed opinions appear on the Thursday before that Friday filing. We look forward to joining you for a reception immediately after the court is closed, just outside in the hallway, and we thank you again for being a part of this proceeding. I'll ask the bailiff then to adjourn court.